All right, Jello again. This is Ben Hitchcock Cross talking to you today. And what do we have here? We've got one of two motions for summary judgment against Deborah Keither by Milwaukee Public Schools. So we're going to start to read out parts of those. Unfortunately, we're sort of going in a reverse order. We're reading out the employment one and not so much the First Amendment one. We've been focusing on those issues because that's what we filed summary judgment on. But this is what I'm working on first. I don't know how it happened, but logically, I could see it being done the other way. But bear with us, okay? All right. I can safely tell you that I have been to 7 dinners in the last 7 days, and you would think that my society would be a little bit too rich for some people, especially since it's been the same people. But everybody's expectations seem to have been met. I'm a little tired. That's about the bottom line. But what's important is everybody's expectations are met and seem to be happy. Okay. Defendant Milwaukee Board of School Directors memorandum in support of its motion for summary judgment. Now, if you are unaware or not, this Title VII, it goes against the employer. So even if your boss is unless the boss is the owner, is directly sexually harassing, assaulting people, etc., it's not against Joe Smith, it's against the Acme Corporation. Okay. So here in this case, the employer is going to be the Milwaukee Board of School Directors. Once again, you're not going to hear me make a lot of comments about the facts one way or the other. Again, these are their facts, their assertions. These assertions are going to be backed up by a proposed findings of fact and citations to the record here. And so we'll leave that to that. Pursuant to Rule 56 of the Federal Rules of Civil Procedure and 56B1A of the local rules for the Federal District Court for the Eastern District of Wisconsin. Jeez Louise. Defendant. Milwaukee Board of School Directors by its attorney Von Briesen and Roper. I forgot it's the Roper part. Submits the following memorandum of law in support of its motion for summary judgment. Feel a little bit better. Oof, we get this a little bit here. This matter arises out of a plethora of amorphous and sweeping constitutional, employment discrimination, and retaliation claims brought by the plaintiff. So he's saying she's full of beans. A former administrator for MBSD, the board, against the board and several of its current and former board members and employees. Defendants Keith Posley, Calvin Furman, Catrice Cotton, Jeremiah Holliday, Robert Peterson, and other board members have filed a separate motion for summary judgment and memorandum in support. This memorandum is brought by the MBSD alone with respect to those claims alleged against the MBSD. There are a few instances where argument made with respect to the individual defendants also apply to the MBSD, and those instances are noted herein. Okay. So again, we're not going to talk about people in their individual capacities. 1983 here, we are talking about employment. A majority of the plaintiff's claims against the board arise out of conduct that occurred between November 19th and December 20th, 2020. November 2019 and December 2020, eventually culminating with plaintiff's administrative assignment out of central office and to Washington High School, Washington, and some. Plaintiff alleges that she was subject to different terms and conditions of her employment, eventually transferred and constructively discharged both due to her race, white, and her sex, female, in violation of Title VII, and retaliation for her supposed political association in violation of the First Amendment, and for allegedly engaging in activity protected by Title VII. Plaintiff also claims that in the years following her transfer, the MBSD infringed on her First Amendment rights by limiting her speech primarily at school board meetings. Huh. Now, so there's the first shade that we saw, just to analyze closely, is that there's a plethora of amorphous, what does that mean? Without form, and sweeping constitutional employment discrimination retaliation claims. Okay. That's the first shade. And then we're getting down here. It says a sprawling, which is again, I would say without confinement, and convoluted, which is, well, I think I'm gonna look that up there. All right, well, that was fascinating. Transferred in consecutive violation in retaliation for supposed political association and violation. I don't understand, I guess, why they're addressing things that aren't being addressed in this motion here, but okay. Despite a sprawling and convoluted record in this matter, the undisputed fact clearly established that the plaintiff's claim against the board are not legally actionable, lack sufficient evidentiary support, or have no merit. Plaintiff's First Amendment political association claim, count one of her Second Amendment complaint, fails because she cannot establish any constitutional injury caused by a board decision maker. And second, because she does not identify any MBSD policy custom or final policy maker action that could support liability. Likewise, on plaintiff's First Amendment infringement claim, count two, against the board, rests entirely on speculation. Huh. The undisputed facts and said so neutral, safety-driven adjustments in response to larger crowds and disruption, not the viewpoint-based targeting that the plaintiff alleged infringed on her constitutional rights. Huh. Okay, with respect to the plaintiff's Title VII discrimination and retaliation claims, plaintiff's claims relating to constructive termination fail because she did not exhaust her administrative remedies with respect to such a claim, and in any event, it fails on the merits because she never resigned. Instead, her employment was considered abandoned for failure to timely extend a leave of absence. What remains are disparate treatment claims tied to alleged, quote, modification, close quote, of plaintiff's terms and conditions of her employment. Many of the workplace grievances she cites do not constitute adverse actions, and she neither met the board's legitimate job expectations nor offers any proper comparator evidence with respect to those that do. Moreover, the board has articulated a legitimate non-discriminatory reason for plaintiff's transfer, a good faith response to insubordination and obstructive behavior within the Department of Curriculum and Instruction where she worked. And there is no evidence that the decision was pretext to mass animus based on race or sex. Okay. Plaintiff's Title VII retaliation claim also fails because the activities she alleges she engaged in are not Title VII protected opposition or participation. The pre-transfer incidents that the plaintiff complains of are not materially adverse, and there is insufficient evidence of any causal relationship between the plaintiff's alleged protected activities and the retaliatory action plaintiffs has put at issue. Accordingly, for the reasons set forth herein, the board is entitled to summary judgment as a matter of law in favor of each of the claims against it. Now, remember, what is the summary judgment? There has to be nothing at issue here. So that's what they're saying. This entire case, there's no substantial fact. And really what this means is the plaintiff just doesn't have enough evidence to make it through this next point, which is this next test. Section 2, factual background and procedural history. A, parties, their roles, and the Milwaukee Board of School Directors. The board is a policy-making body of the Milwaukee Board of School Directors serving approximately 69,000 students with more than 150 schools and more than 8,500 employees. The superintendent of Milwaukee Public Schools serves underneath the board and is responsible for overall management of MPS. You'll have to excuse me. All right. During the time period relevant to the plaintiff's claims, Keith Posley served as superintendent. Furman served as deputy superintendent. Dr. Catrice Cotton served as the chief of school administration. Dr. Jeremiah Holliday served as the interim chief academic officer during the period of time at issue. Holliday also effectively backfilled the role of managing the C&I department from May 2020 through October 19th, 2020, when Saffold was hired as the senior director of the C&I department. Matt Chasen served as MPS Senior Director of Accountability and Efficiency. In this role, he accepted and investigated whistleblower complaints on behalf of the board. Plaintiff was employed by the Milwaukee Public Schools from 1995 until 2023. During the relevant time period, plaintiff served as literary education manager until December of 2020. In that role, plaintiff reported directly to the senior director of C&I. That would have been Saffold at that time. On December 29th of 2020, plaintiff was administratively reassigned to Washington High School to serve as an administrator on special assignment. Effectively January 4th, 2021. Plaintiff's employment was eventually terminated for being absent without leave on August 10th, 2023. Okay. On November 21st, 2019, the MBSD considered Dr. Holliday's appointment to the position of permanent chief academic officer and declined to appoint him to the position. The board's decision was based in part upon the receipt of a number of anonymous petitions that describes Dr. Holliday's leadership and management issues while serving in the role on an interim basis. The identity of the authors of these anonymous petitions remains unknown. The plaintiff claims that she assisted the president of the Milwaukee Teachers Education Association, Amy Mizyako, in collecting these anonymous petitions. Dr. Posley, who was at the November 21st, 2019 board meeting, was not aware of the specific nature of the complaints or who made them. And Dr. Holliday was wholly unaware of the existence of the complaints. Okay, that's very possible that on November, I think what that's saying is just, for my understanding, that on November 19th, Posley was not aware of the specific nature of the complaints or who made them, and Holliday was wholly unaware of the existence of the complaints. Okay. Dr. Holliday. Now, just so we're all clear, I, Ben Hitchcock Cross, don't believe or disbelieve the accuracy of many of this. I very likely will dispute this vigorously, but that's not what this is about here. We are just reading through this. On October 6, 2020, plaintiff and two of her colleagues in the C&I department met with Mr. Furman to report concerns related to Dr. Holliday. They presented a lengthy written complaint referencing several issues with Dr. Holliday's leadership and management style. Mr. Furman reviewed the materials, categorizing them as, quote, bad manager type concerns, close quote, and did not disclose to Dr. Holliday who raised these concerns. On November 18th, 2020, plaintiff submitted an internal complaint against Dr. Holliday to Yashika Spears, a compliance specialist in MPS's Employee Rights Administration Department. The complaint against Dr. Holliday did not contain any mention of race or sex-based discrimination. Sometime in October or November of 2020, plaintiff began communicating with Mr. Chasen regarding what she perceived as wrongful conduct directed against her, including purported complaints about the hiring process for the CNI senior director. Matt Chasen does not recall plaintiff ever asserting that these actions allegedly being taken against her were due to her race or sex. Mr. Chasen's stated intent was to keep plaintiff's complaint confidential for as long as possible. After Dr. Saffold was hired on October 19th, 2020, plaintiff repeatedly engaged in unprofessional and insubordinate behavior towards her. I assume that's Dr. Saffold. Although plaintiff claims that Dr. Saffold engaged in inappropriate and harassing behavior at the direction of Dr. Holliday and others, there is no evidence to support this assertion. Throughout November and into December 2020, plaintiff disrespectful and confrontational behavior towards Dr. Saffold and disruptive conduct during department meetings continued to escalate. So much so that Dr. Saffold held a non-disciplinary supervisory meeting with plaintiff on December 2nd, 2020, where she addressed plaintiff's conduct. On December 4th, 2020, plaintiff filed an internal complaint with Ms. Spears against Dr. Saffold. This complaint also contained no reference to race or sex-based discrimination. C. Plaintiff's administrative reassignment to Washington. After December 4th, plaintiff's insubordinate conduct directed towards Dr. Saffold continued. Specifically, plaintiff's emails with Dr. Saffold in late December 2020 reflected a refusal to productively engage on a literacy curriculum for the 2021-2020 school year, or answer Dr. Saffold's direct questions on the topic. Instead, plaintiff professed confusion, accused Dr. Saffold of being inept, and stated that she had not been passing along questions from her subordinates for fear of being combative. Dr. Saffold, when asked by Dr. Posley about the literacy plan delay, reported the issues of plaintiff to Dr. Posley and presented him with emails on the topic on December 29th, 2020. Dr. Posley was concerned that based on Dr. Saffold's emails, the plaintiff's obstructive conduct was preventing essential work on reading/literacy platforms for students learning at home in the midst of the coronavirus pandemic. Dr. Posley decided to administratively reassign plaintiff as a strategic step to move the district forward and directed Mr. Furman and Dr. Cotton to effectuate the reassignment. At the time of that decision, Dr. Posley was not aware that the plaintiff had made complaints against Dr. Holliday or Dr. Saffold, and he had not received complaints from ERAD regarding plaintiff. All right. We're going to pause it right there for now. Holy cow, 20 minutes. And we'll start it up again, I'm sure. Thanks for sticking with us. We'll keep you informed.